Hey everyone, let's get right into it. Today, we are diving into a meticulously detailed explainer of the appellate body report on the Canada Autos case. Now, I know many of you are watching this specifically to prep for your international trade law exam for your BALB course, so listen up because this is an absolute must-know case. We are going to look incredibly closely at the legal mechanics of this ruling. I'm going to give you every single detail you need to ace that exam, because honestly, this isn't just a case about cars. It's practically a masterclass in how the World Trade Organization interprets discrimination, subsidies, and those incredibly blurry lines between domestic industrial policy and international trade violations.
Here is our roadmap for this session. We are going to tackle this using a structured IRAC approach: issue, rule, application, conclusion. We'll start with the factual background of the Canadian measure, and then move sequentially through GATT's most favored nation rules, how we define a WTO subsidy, export and local content contingencies, before wrapping up with the final legal verdict.
All right, part one, the Canadian auto measure. Let's lay out the facts.
To understand the legal violations here, we first have to establish exactly what Canada was actually doing. The whole foundation of this dispute rests on two things: the MVTO 1998, which is the Motor Vehicles Tariff Order, and various SROs, or Special Remission Orders. Basically, these legal instruments allowed specific big-name manufacturers, think General Motors, Ford, Chrysler, and Volvo, to import vehicles into Canada completely duty-free. And here is a critical fact for your notes. Because of Canada's obligations under the 1989 CUSFTA, which was the precursor to NAFTA, this list of eligible manufacturers was permanently closed, meaning absolutely no new companies could ever qualify to get on it.
Keep your eyes on this specific baseline number, 6.1%. Normally, Canada applies a 6.1% Most Favored Nation, or FFN, tariff rate on imported motor vehicles. That's their standard, bound ad valorem rate sitting right there in their WTO schedule. So that 6.1% is precisely the tax that these select closeless manufacturers were completely avoiding when they imported their vehicles.
But, there's no such thing as a free lunch. To get that 6.1% tariff waived, those eligible manufacturers had to meet three intensely strict conditions. First, they had to have a manufacturing presence in Canada actually producing vehicles during a specific base year. Second, they had to maintain very specific production-to-sales ratios. And third, they had to hit targeted Canadian value-added, or CVA, requirements. Highlight these three conditions in your mind right now, because they are the exact targets of all the major legal challenges we are about to unpack.
Moving on to Section 2, GATT Article 1.1, the Most Favored Nation Principle.
So Japan and the European communities stepped up and brought the first major claim here. Canada pushed back hard, defending their measure as origin neutral. They argued, hey, our law doesn't say only cars from the US get the exemption. It just applies conditions to the specific companies importing them. But the appellate body firmly shut that down, establishing that Article 1.1 covers both de jure and de facto discrimination. For your exam, remember this distinction. Even if a law doesn't explicitly name a country on paper, which is de jure, if its practical, real-world effect discriminates based on origin, it's a de facto violation of the treaty.
And here is exactly how the facts completely dismantled Canada's defense. Because only a closed list of manufacturers could qualify, and because the automotive industry is absolutely famous for practicing intra-firm trade, the outcome was massively skewed. Think about it. GM in Canada imports GM cars from the US. Toyota in Canada imports Toyota cars from Japan. But since Toyota wasn't on that closed list, their imports got hit with the full 6.1% tariff, while GM's imports just cruised in duty-free. So in practice, the exemption heavily favored vehicles originating from a very limited number of countries.
This crucial point is captured perfectly in this quote right here from the appellate body. The actual text of GATT Article 1.1 demands that any advantage granted to a product from one country must be accorded immediately and unconditionally to like products from all WTO members. By limiting this massive duty exemption to a closed, exclusive club of manufacturers who exclusively imported from their own affiliates in select countries, Canada completely failed this unconditional requirement. Bottom line, de facto discrimination is still discrimination.
All right, Section 3. Let's talk about defining a WTO subsidy under SCM Article 1.1. Having established the GATT violation, we shift gears over to the SCM agreement. If you underline one thing for your BALB exam, make it this exact two-step test to define a WTO subsidy under SCM Article 1.1. Step 1. There must be a financial contribution by a government. And the treaty explicitly says this includes situations where government revenue otherwise due is foregone or not collected. Step 2. A benefit must be conferred. Now, nobody was arguing that avoiding a massive tariff wasn't a benefit. The entire legal fight was over whether this 6.1% was actually revenue otherwise due.
The appellate body actually pulled precedent from the famous U.S. FSC case to confirm how we define otherwise due. They stated you need a normative benchmark, and the irony here is that Canada itself established that normative benchmark, their standard 6.1% MFN tariff. By waiving that specific established benchmark for a select few companies, the Canadian government voluntarily gave up an entitlement to raise revenue it otherwise would have collected. So legally speaking, this tariff waiver perfectly fits the definition of a financial contribution, making it a definitive subsidy.
Moving to Section 4, Export Contingency. Specifically, whether it was contingent in law.
Now that we've established it's a subsidy, we have to analyze SCM Article 3.1a. And this is where the math becomes a literal legal trap. Remember those production to sales ratios we talked about earlier? Let's break the math down. If an SRO saddled a company with a 100 to 100 ratio, it meant for every 100 units of value they produced, they had to sell 100 units in Canada. The absolute only way to earn the right to import vehicles duty-free without violating that strict ratio is to export your Canadian production. Even for companies with ratios under 100, say 95 to 100, they'd get a tiny base duty-free allowance, sure. But if they wanted to infinitely increase their duty-free imports, they were mathematically forced to export. Naturally, Canada fought this aggressively. Their main defense? The law never explicitly used the word export. Therefore, there was no de jure or in-law contingency. But the appellate body struck that down completely, setting a vital rule you need for your exam: contingency in law absolutely does not require the exact word export to be written on the page. It includes implicit conditionality derived by what they call necessary implication from the words actually used. The mathematical formula was the law, and the formula implicitly demanded exporting.
So, the appellate body upheld the ruling that the measure is a prohibited subsidy under SCM 3.1a. It's a simple, undeniable equation. The more you export, the more you can import duty-free. That clear relationship of dependency means the subsidy is, without a doubt, contingent in law upon export performance.
Let's move to Section 5, Local Content and CVA, falling under SCM Article 3.1b.
Now, we are going to look at the claims that the Canadian Value Added, or CVA requirements, were illegal local content subsidies. And pay super close attention to this list, because this is the one place where the complainants actually lost. To meet the CVA requirements, a company had to prove a certain amount of Canadian value. But look at the eligible costs that count towards that value. Only the very first bullet point involves actual domestic physical goods, like parts and materials. The rest of the list? Transportation, labor, overhead, administration, and depreciation.
The EC and Japan argued that since using domestic goods was at least one of the ways to meet the CVA requirement, the subsidy gave an illegal preference to domestic goods. But the panel, and this was upheld by the appellate body, noted an incredibly critical distinction. Because the CVA is calculated as a broad aggregate of costs, a manufacturer could theoretically meet their entire CVA requirement by just using Canadian labor, paying for local overhead, and calculating depreciation without using a single domestic physical good.
And it all comes down to the exact, literal wording of SCM 3.1b. The treaty strictly prohibits subsidies contingent on the use of domestic over imported goods. It doesn't say services, and it doesn't say labor. Because getting access to the duty exemption wasn't strictly 100% dependent on using domestic goods, the appellate body agreed that the complainants simply failed to prove in-law contingency under 3.1b.
Finally, Section 6, the final legal verdict. Let's look at the summary of the rulings. Let's put all the pieces together and synthesize these incredibly dense rulings. In summary, Canada took a major hit here. Their closed-list exemption, even though it looked origin-neutral on paper, was a massive de facto violation of GATT Article I-1 because of how intra-firm trade actually operates in reality. On top of that, their ratio requirements constituted an illegal export subsidy under SCM Article 3.1a because of that implicit mathematical contingency we discussed. But they did survive the claim under SCM 3.1b since the value-added requirements didn't strictly mandate the use of physical domestic goods. Just to round out your notes, the measure also violated GATT's Articles 2 and X17 regarding trade and services, which just further complicated Canada's legal standing.
Now here's a massive procedural point for your LLB exam before we wrap up. The appellate body heavily discussed and ultimately upheld the panel's right to use judicial economy. The EC had complained that the panel totally ignored one of their alternative claims about the CVA causing expert contingency. The appellate body stepped in and essentially said, look, panels don't have to waste time ruling on every single redundant legal claim once a violation is already established on a measure, as long as they provide a positive resolution to the dispute. It's a vital concept in WTO dispute settlement that you absolutely need to know.
So, as you hit the books and continue your exam prep, I want to leave you with this provocative thought. Think about international trade holistically. If a domestic law that never once mentions a specific country and never explicitly demands a single export can still be completely struck down by a strict mathematical interpretation of de facto discrimination, how does this completely reshape the boundaries of modern global trade? When governments sit down to design domestic industrial policy today, they aren't just drafting laws anymore. They are literally writing complex equations that the WTO will rigorously audit. Good luck with your studies, keep reviewing these strict definitions, and I'll catch you in the next explainer.